Okay, so this is my quick talk on legal and ethical considerations for TV producers. This is just a quick run through of some of the basic concepts that you need to know when you are out in the field. Everybody should recognize this statement. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press. So everybody should recognize this as the First Amendment. All media law in the U.S. almost all media law in the U.S. stems from the First Amendment. It's the first provision of the Bill of Rights. The Bill of Rights was the first changes that the Founding Fathers made to the Constitution. It became part of the Constitution in 1791. However, it was not applied to the states until the 1920s. It used to be that the states could make their own laws regarding freedom of expression until 1920, and then they had to abide by the federal laws. So there are 5 main organizations that make media laws and regulations in the U.S. Local governments make some of them, state governments, Congress, the Federal Communications Commission, and the Federal Trade Commission also is involved in making media laws. The FTC, by the way, is mostly involved in making laws regarding advertising. So if you have claims of false advertising, for example, that would be a matter for the Federal Trade Commission to take up. Broadcasters have been regulated by 3 main acts over the past century, beginning with the Radio Act of 1927, which we talked about a little bit in class. This was the first attempt at the federal government to regulate radio, and specifically it gave the Federal Radio Commission the right to allocate licenses. And it was important to allocate licenses because initially everybody was being a radio broadcaster, which meant that multiple stations would go up in the same area and the signals would cancel each other out. It's in 1927 also that the federal government initially regulates radio content as that being in the public interest, convenience, or necessity. In order to secure a license, a radio license, and today in order to secure a broadcast license, you have to show that you are serving the public interest, convenience, or necessity. The Radio Act of 1927 regulated both radio and TV, even though TV was still being developed. In 1934 is the Communications Act. This is where the Federal Communications Commission is born, and it replaces the Federal Radio Commission. And it set technical standards for radio, telephone, and television. There were a few minor changes in our Communication Acts until 1996, but it is in 1996 where the biggest changes occur. And basically what happens is this. There used to be a lot of what they called cross-ownership restrictions, where if you owned the local newspaper, you could not also own the local television station. This was considered to be important because there were only so many outlets for mass media communication, before 1996, like newspapers, magazines, TV stations, radio stations. It was considered that if one organization owned all of them, that it would have too much of an influence over what the citizens of that area would think or see or understand as being important for the news. So part of this kind of broadcast regulation was the intention to make sure that diversity of opinion was available. But in 1996, you're about 4 years into the internet. Fax machines, cellular communication is starting to come into its own. And so the government kind of looked at this and said, we don't need to regulate cross-ownership as much as we used to. We can really let people own as many broadcast outlets as they would like, even if they own the local paper. And this was because they felt that the internet and cellular services, they provided such a large number of competing mass communication vehicles that the cross-ownership restrictions and something having to call the scarcity principle no longer applied. In 1996, they also included internet service regulation in the new broadcast regulations, even though the internet was very young. And they tried to move more towards a policy of regulating media by content instead of technical platform. So to this day, broadcast television producers have less freedom of expression than newspapers. And that's because the FCC still thinks that it's in their best interest to minimize offensive, mostly offensive, sexually explicit, or other kind of communication from broadcast. Cable has much greater leeway, and newspapers and film have the greatest leeway of all. But 1996 did reduce some of the restrictions on broadcast communication. Cable TV is regulated in part by local governments, and the reason why cable TV is regulated in part by local government is because in order to bring cable services to your house, the cable company had to dig up the streets to literally lay the cable from their office to your home, to your curb. And because of that, they had to get a lot of permits from local governments. So a lot of times what local governments will do is that they will make sure that there's an inexpensive basic tier cable package available to residents who want cable television but do not want to pay high prices for cable TV. Cable companies also must find a way to lock out objectionable channels, and they must provide ratings for their programs. So if you're in a house, for example, with little kids, you can ask the cable company to help you put a lock on more adult channels like the Playboy channel, for example, or maybe a channel where you think there's a lot of violent content, like sometimes Spike or AMC has very violent content. The ratings serve a similar purpose. They let parents know the maturity level of the audience that the content is targeted to. There are some other regulations in terms of the kinds of programming that cable networks may provide. They're limited to 12 minutes of advertising per hour during programming targeted to children under 12 years of age. And again, this grows out of concern that you do not want to overexpose children to advertising messages. Political candidates who are running for office, if, for example, using the last election as an example, if Hillary Clinton bought a 60-second ad on CNN, CNN would have to also offer to the Trump organization the opportunity to buy the same amount of advertising at the same price. Some cable system operators and cable networks do not run political advertisements for this reason, because they do not want to have to run everybody's advertisement. Local governments may also ask cable companies to set aside some channels for public education or governmental use. And the cable operators may not control the content of these channels. If you have Comcast in Miami-Dade, you'll notice that around the teens and 20s, there's a bunch of local government channels. Those are covered under the public education or governmental use channel allocation. So the local municipality negotiated with Comcast for those channels. So the courts have a role in setting regulations for media in the U.S. Mostly what they do is they apply and they interpret the law. The U.S. Supreme Court is the final court of appeal, and the Supreme Court's role is to interpret laws and regulations in light of the Constitution. And mostly they interpret it in light of the First Amendment that requires freedom of the press. To a lesser extent, they will also use Fourth Amendment, which has to do with privacy, which we'll talk about in a minute. The chilling effect is a phenomenon that occurs when court rulings or new regulations or new laws come into effect that reduce the protections for journalists and other media workers. And the chilling effect is called this because it can suppress certain types of reporting, because news agencies fear legal reprisal. Prior restraint is a very important concept in the freedom of the press. Prior restraint is an official restriction of speech prior to publication. In our country, you can publish anything that you like, pretty much. You can go ahead and publish it. If it's defamatory, if it violates someone's privacy, whoever you defamed, whoever's privacy you have violated, they have to sue you after the fact of publication to get redress for their wrongs. They have to actually actively sue you. Prior restraint is the idea that you would prevent something from being published in the first place. In our society, we do not have many instances where prior restraint is allowable. And in 1976, the Supreme Court said prior restraints are, quote, the most serious and least tolerable infringement on First Amendment rights. However, they did say that it could be possible in light of national security or other areas where the public good may justify prior restraint. They left the door open that prior restraint could be a possibility, that a government agency, for example, could seek to prevent something from being published for the public good. There are 6 areas of media law that media workers need to be aware of. They're listed here: defamation, invasion of privacy, trespass, use of the telephone, obscenity, and copyright. So defamation, which is sometimes referred to as libel or slander. Libel used to refer to printed defamation and slander to spoken defamation, usually in conjunction with broadcasting. Now we refer to them both as defamation. But it's the use of factual information that holds someone in hatred or contempt, subjects the person to ridicule, or otherwise lowers esteem for the individual. So if you say something that is untrue about someone, and they can prove it, that is defamation. If you give an opinion about someone or something, and it's clearly an opinion and not a fact, that's usually not a case of defamation. So for example, if I published on my blog that my neighbor beats his wife, and I state it as a matter of fact, and that was not true, the neighbor could take me to court and sue me for defamation, and the neighbor would probably win. If I wrote in my blog, I think that Ben & Jerry's Cherry Garcia is a disgusting ice cream, Ben & Jerry's would not be able to take me to court to sue me for libel or slander or defamation, or they could, but they would not win because I have written it as an opinion, a personal opinion. So a defamatory statement becomes the basis of a civil lawsuit. It's not illegal to defame someone, but you can be sued. Properties, businesses, and institutions can also be defamed, as in this case, a corporation is indeed considered a person. In our society, it's harder for public figures to sue successfully for defamation than private individuals. Public figures include celebrities, government officials, and publicity hounds. Celebrities include people like our friend here, Pamela Anderson, and her boyfriend. I don't remember his name, but he was in a boy rock band in like the early aughts. This image is from a website called PerezHilton.com. About 10 years ago, Perez Hilton was probably the #1 celebrity blogger, and he used to take pictures of celebrities, and as he used to say, telestrate them. He would draw on them. In this instance, he just wrote the word herpes on the hat of the boyfriend, indicating that the boyfriend perhaps has herpes, right? Okay. So in this case, because Pamela Anderson and her boyfriend are public figures, it would be difficult to impossible for them to sue Perez Hilton and win for writing herpes on this gentleman's hat. The reason for that is because people who put themselves into the public eye, celebrities, but more importantly government officials, the idea here is that they deserve a great level of scrutiny. And so expression where they are concerned about them should be much freer. So celebrities, government officials, that means anyone who's elected to office. That also includes people who are appointed by presidents, mayors, governors. That includes sometimes heads of agencies, public figures. The one thing to remember about defamation is that truth is an absolute defense against defamation. So for example, if we go back to the Pamela Anderson example, if her boyfriend did try to sue Perez Hilton for putting herpes on his hat, If Perez could prove that this gentleman had herpes, he would be innocent of defamation. They could not sue him and collect damages for defamation. Again, in this case, this probably wouldn't happen anyhow because Pamela Anderson's boyfriend is a public figure. So when media are actually taken to court in jury trials, they lose 70 to 80% of defamation suits that go to the jury. People, average citizens who serve on juries, they don't like media defamation suits. Most of these are overturned on appeal because either it involved a public figure, or it was found to be true, or it was the standard of untruthfulness was not met. So if you're going to seek damages for defamation, you must show that even if the information was false, that the media showed a reckless disregard for the truth in publishing it. So it's not just a matter that the media got a fact or two wrong. That's not going to meet the standard of libel. It must show that there was a reckless disregard for the truth. And so part of what could happen here is if you accuse someone of a crime and you don't fact check it, that could easily be found to be a reckless disregard for the truth. But if you, in writing a story about someone who was in legal trouble, if you get some facts wrong, like if you get their address wrong, or if you say that they were divorced from someone that they were never married to, that would probably not be considered a reckless disregard for the truth. And again, the truth is an absolute defense against defamation. Generic video are video images or other photos of generic people in the street that are used to illustrate a point that a media worker is making. So for example, you see a lot of news stories about obesity, and when the camera sort of pans a crowd of people, they always pan the midsections. Part of the reason why they do that is that they do not want to show the faces or make the people identifiable, because it could be potentially defamatory. Generic video is something you want to be very careful about using. A lot of defamation and invasion of privacy suits have stemmed from the use of generic video. For example, again, using the sort of random people in the street. Suppose you're going to do something on herpes. If you ran an image like this and you said, "Is there a cure for herpes?" Obviously not. That could be potentially defamatory. Using the same stock image, you could have a news report that started something like, "This area is rife with prostitution." Those words would perhaps imply, or could be interpreted as implying, that the women in the photo were prostitutes. That would be potentially defamatory. Another area that's very tricky, especially, and has gotten trickier, is the notion of invasion of privacy. The courts have ruled that the Fourth Amendment has an implied guarantee to privacy. The Fourth Amendment talks about the right of the people to be secure in their persons, houses, papers, and effects. And so what that means, as a media person, you cannot enter into someone's private home. You cannot enter into a private business and use recording material without permission. Or if you do, and you are asked to leave, you must leave immediately. For media workers, invasion of privacy is any act of intrusion that occurs without an individual's consent, including trespass and publication of embarrassing facts, even if true. There are some exceptions to this. Public figures have less protection against invasion of privacy than private individuals. And again, public figures include celebrities, government officials, and publicity hounds. They still have more protection from invasion of privacy than they would, say, in the case of defamation. So, for example, you cannot build a ladder to see over the fence around Britney Spears' house to take pictures of her sunbathing by the pool. That would be invasion of privacy. But you can, if you are on the street and she is in her car with her children, you can use a camera to take pictures of them because that occurs out in public. However, anytime a person, public or private, does something in public, material that's already part of the public record or activities that occurred in public, they are exempt from invasion of privacy protection, no matter how embarrassing they might be. Trespass is related to invasion of privacy. This involves entering private property without permission. And this happens sometimes when you want to do a story involving a business, involving someone in their private home. You need to ask permission to enter most properties when you have recording equipment. This includes stores, restaurants, private homes, and other areas of private property. So restaurants and other merchants, they have what's called a limited invitation to the public to enter their premises. So it does not include an invitation to the media to come in with recording equipment. And some organizations have sued the media for trespass when they published unflattering information about their businesses based on recordings that they made while they were on private property. So sometimes news organizations have been sued for trespass because they could not be sued for defamation. The most famous case regarding a news organization being sued for trespass is Food Lion. This is where ABC News sent a couple of undercover producers to Food Lion where they posed as employees, and they recorded undercover video of unsanitary handling of meat products at the Food Lion grocery chain. ABC News broadcast this in 1999 on a show called Primetime Live, and the Food Lion grocery chain sued ABC for trespass, for taking cameras onto their property without permission. And they sued them for trespass because they could not sue them for defamation because the cameras had recorded true issues with their handling of meat, but they could get them on trespass because they were on private property and recording without permission. So initially a jury awarded Food Lion $5.5 million. On appeal, it was reduced to $316,000, and then it was later overturned. This is often the case with judgments against the media. Public jury will usually award a large amount, and it's often overturned. But just remember that as a media worker, you can be sued for trespass as an alternative to defamation when true but unflattering information is published. So make sure you have permission to be on someone's property. Technology like telephoto lens and hypersensitive microphones have increased the scope of what could be called invasion of privacy. And this has happened to such an extent that because of things like news helicopters, a lot of state property lines now extend to the heavens. So just as you cannot climb a fence or build a ladder to take pictures of Britney Spears in her backyard, you cannot fly a helicopter over her home to take pictures of her in her backyard. The FCC says you must notify people if a telephone conversation is being recorded or being broadcast before the broadcasting begins. Now, the exception to this is where people call into a call-in radio show, such as Rush Limbaugh's. So in this case, it can be assumed that the person who is calling in understands that they will be broadcast. In Florida and in some other states, all people who are on a telephone call must give their consent before the call can be recorded. This is a very important concept to understand. This question will be on the exam.